Well, thanks, Annette. Everybody out there, all 38 of you. It's not a worldwide audience, but I'm honored that you're joining us. Please be patient with me as we struggle through PowerPoint. That's not one of my strengths, but we've got to do it this way. So if I mess up, we'll fix it here. So here goes. Let's see. Oh, there's my disclaimer. Blah, blah, blah. It's basically saying I'm nobody's lawyer. You guys should understand that this is purely educational and it's not legal advice. I'm going to say some legal things in here, but this does not represent the legal opinion of MetroTex. It doesn't represent the recommendations of MetroTex. These are just my own thoughts and ideas to help you guys, and we'll interact a little more at the end when we do questions. And I'm sure you guys will have questions as I'm speaking, so the technology exists for you guys to just pepper Annette with your questions. She's going to keep them all, and then we'll try and hit them at the end. Okay, so what is a survey? This is kind of my own definition. This is not any formal legal definition, but a survey is basically a graphical representation of land. It can show all sorts of things. It can and often does show improvements on the land, fancy word for structures. It usually shows boundaries or boundary lines. Surveys can show building setbacks. Now, there are different types of setbacks. Usually the ones we're talking about in the title insurance arena or seller-purchaser arena are platted setbacks, but there are also setbacks created by cities through zoning and code, and those could be shown by a certain type of survey. Surveys can and often do set forth floodplain areas, either very specifically or maybe generally. They may have a statement that says this property is not located within a floodplain, or it's generally located within floodplain Y, and it might show the approximate areas of that floodplain, or it may show the exact areas of the floodplain. Surveys often show easements and easement areas, which are important to know because easements are rights in third parties to use part of that land. So you want to know who has a right to use that and what exactly is that right and where is it. Some surveys show roads and rights of way. Some surveys show the elevations of land, which is pretty self-explanatory, and we'll look at some surveys that do that. Those can be very informative. We often don't have to deal with that in residential real estate, but in commercial real estate it's often a bigger factor. Surveys can show natural features such as lakes and rivers and streams and creeks and even trees. Builders especially are concerned about trees and where they are and how big they are because some city ordinances prevent them from moving them or taking them down, so they want to see those things. Surveys will often show, certain types of surveys will show paving and pavement and where they lie. Surveys can even show restrictions and restrictive covenants applicable to the land. Now, those really aren't graphic in nature, but a survey will have a note sometimes that say the restrictive covenants in volume X, page Y, apply to this lot. Or they might say the restrictions in volume X, page Y, do not apply to this lot. And that's useful information. The surveyor is determining what land is applicable to the title work. Surveys can also show parking areas and spaces. Especially in commercial, it's important to see the number of parking spaces because those have certain requirements by cities. You've got to have a certain amount of parking for various ventures. Surveys can also show zoning, which may be important to you because you may have a use, you may be purchasing a piece of property that has a different use than what it is currently zoned for. You may want to see what that zoning is. Surveys often show ownership of the land and ownership of the neighboring tracts. Depending on the type of survey, again, and the survey standards used, you can see who your neighbor is according to the deed records and have it graphically reflected on the survey. And surveys can also show what recorded matters do not affect the land that has been surveyed. So if your title work comes out and lists 3 easements, and the surveyor does his or her work and determines that one of those easements actually, contrary to the title commitment, does not affect your particular property, they will say that on the survey. and that will enable the buyer to know that easement doesn't affect. It will enable the buyer to ask the title company, look, you've listed an easement as an exception. It doesn't really affect the property. Please remove it as an exception. And in that respect, surveys are very useful to buyers and title companies, because sometimes it's very hard for a title company, based on a very general legal description, to determine whether a particular easement does or does not affect a piece of property. So, as we just said, different types of surveys depict different aspects of those features. Now, here's a question that comes up a lot. Is a survey an original work which may be copyrighted by the surveyor? And what are those copyright notices about anyway? Let's take a few minutes to kind of talk about where surveys have been and how the title industry has affected them. It's very interesting. But you will often, if not always, see a copyright notice on your survey, and you may wonder, why have surveyors begun copyrighting these drawings? The very simple answer is because surveyors have lots of money taken out of their pocket through the use of older existing surveys. It's fairly commonplace now in sales transactions for a seller to provide their existing survey and throw an affidavit on top of it that says, since the date of this survey, nothing has changed. Well, you can imagine when that practice really began to take off, the surveyors were not happy about that at all. It meant perhaps statewide billions of dollars of revenue lost. And so surveyors went on the offensive to try and combat this practice. They feel that surveys are a good, important thing. They're worth the money. I do too. And they went about it different ways. They tried to get laws passed at the legislature to require the use of a new survey in certain circumstances. That is a somewhat anti-consumer measure, if you think about it. Consumers should have a choice as to the amount of risk they take, so that died. Then they tried to go to the title industry and their state agency, the Texas Department of Insurance, and get a regulation passed that required the use of a new survey in certain circumstances. And again, the department felt that was an anti-consumer measure, and that failed. They felt that people should have the choice. New surveys are a good and valuable thing, and they should be used all the time, but people can choose to take risk and use old surveys if they feel the circumstances merit it. So the idea of a copyright came about. Now, I will say I am not an intellectual property expert. I'm not a patent lawyer or a copyright lawyer. I've just read a few articles about this. And certain things can be copyrighted. This is my limited knowledge of copyright law. Things that are an original work. So a survey or survey type work could be original in some respects and could be copyrighted. For example, a developer hires a surveyor and an engineer or both to lay out a development, and they find unique or innovative ways of access. They move easements. They plan a whole shopping center or a whole office building around some difficult natural features such as floodplains, rivers, streets. That type of work may in fact be copyrightable because it is original thinking and planning by that surveyor and the engineer. On the other hand, many of the surveys you guys use, a lot and block residential survey where the surveyor is pulling up the title work and drawing the boundary lines and drawing the easements, it's hard for me to think and understand how that can be an original work. Essentially, the surveyor is saying, well, the way I drew these easements is original and unique, and no one else can draw them this way. And I think that's kind of a laughable argument, and so I would say the copyright might not hold there. Nevertheless, you have to be aware of these things. You have to be sensitive to what the surveyors are thinking and doing, and it really goes into the discussion we have later about using old surveys and the risks you take. I did see a few years ago a demand letter from a lawyer or a law firm in Sherman to several title companies threatening to sue for the breach of this copyright. And I think it was mostly a scare tactic. I did not see any federal copyright lawsuits get filed. Those are very expensive. But you have to keep in mind that surveyors are going to be very protective of their work product, and if you use an existing survey, you will probably not have the opportunity to ask the prior surveyor questions, or you could certainly ask them, but they're not going to be willing to help you clarify a work they've done for which you've paid no money. So be sensitive to that issue. Use surveys and affidavits, or kind of take what you get and you cross your fingers and you hope that they are accurate. Okay, so we have different types of surveys. The survey standards for different types of surveys are set forth in this book called The Manual for Practice for Land Surveying in the State of Texas, comprised of standards for land surveys, specifications for categories of surveying, and ALTA ACSM surveying standards. The, quote, manual. It's a big, long word. But the manual is what surveyors go by, and the manual sets forth 9 categories of surveys. And the first one is already up there, a land title survey. A land title survey is defined as a thorough review of significant factors affecting and influencing the location of boundaries, ownership lines, rights of way, and easements within or immediately surrounding a particular parcel of real estate. The Category 1A is what is classically used for a title-insured real estate transaction. It's the one, you've probably seen it many, many times. It's your standard land title survey. In fact, that's the nickname for it. But there are other categories you need to be aware of. There's something called a standard land survey. This is a boundary survey only. It does not attempt to locate any improvements and internal features. So if for some reason you just needed the boundary lines charted out, you might be able to get a Category 1B survey. A Category 1B is rarely used by title companies for insuring purposes because it simply just shows the boundaries of the property. And there's much more information that purchasers, lenders, and title companies need to see. Category 2 is called a route survey. It is used to establish the location of lineal projects, such as roads, canals, utility transmission lines, all those things that are frequently described in terms of a center line. And so you're not charting out a particular tract of property, you're charting out a route. Railroads, for example, rights of way. I know DART, for example, years ago when they became established as a quasi-governmental entity and began taxing people and establishing these DART lines, they purchased rights of way and railroad lines from the old railroads, and they used these route surveys, which are very hard to read and understand. A locative survey is sometimes called a layout survey or a site plan survey, and it is used prior to construction to establish the location of buildings and other structures in relation to the boundaries of the property. It locates improvements and shows how far they are from the boundaries. Again, it is not as comprehensive as a Category 1A. It is not a land title survey, and generally cannot be used for title insurance purposes, but it is a category. Category 4 was simply deleted. At one time there was a Category 4 called a mortgage loan inspection survey, and this was split into Category 1A and 1B, so that's where Category 4 went. Category 5 is a construction survey. This survey is typically a follow-up from a locative survey. Once that's done, you do a construction survey. It may be conducted during or at the conclusion of construction. It is sometimes called an as-built survey, and you probably have heard of that term. Category 6 is a topographic survey, which I will refer to sometimes as a topo. This survey is intended to disclose the elevations and configurations of the land and improvements. It usually includes cross-sections and contour profiles, and I think I've got an example of a topo in our materials which we will jump to. I've got a number of PDFs, and a classic topo has dashed lines to show decreasing or increasing elevations, and it can be very confusing. It's a lot of data. Sometimes a topo is laid on top of perhaps a land title survey or an ALTA survey, but sometimes you need the information. Category 7 is called a horizontal control survey. This is a type of master survey, they call it, designed precisely to coordinate horizontal position data into a framework to which other surveys are referenced. What does that mean? These very Detailed surveys are needed for construction of water and sewer systems, pipelines, highways, bridges, tunnels, and dams. That's what they use for those. A vertical control survey is very similar. It's also a master survey that establishes particular control points of elevation measured against mean sea level. These are used for dam or lake construction and tidal and subsidence studies. The last category is called an investigative survey. This survey category describes surveys that are used to conduct investigations on very specific physical properties of the land. Classic examples include litigation matters. You hire a survey and say, I need you to check out this particular boundary. There might be some conflicts with some old recorded deeds. Conflicts about encroachments or just questions about encroachments, or even checking the work of others. You take a look at the survey and re-verify its accuracy. This is somebody I don't trust. Again, an investigative survey is highly focused and is not used typically in connection with a sale. Now, in addition to these 9 categories, surveys, the manual divides each of these 9 categories, into 4 separate conditions. Okay? The conditions describe the primary land use of the area being surveyed. What is it used for? And they set forth measurement precision criteria. A suburban condition, for example, does not have as stringent a measurement tolerance as an urban condition. So condition 1 is called the urban business district. That's a downtown business district of any city, town, or village. Downtown Dallas, downtown Fort Worth. You might, for example, have a Category 1A Condition 1 survey if you were doing something downtown. Condition 2 is urban, and that is defined by the manual as all land within the corporate boundaries or limits of a city, town, or village lying outside a downtown business district. So it has different measurement criteria. Condition 3, which many of you probably deal with, is suburban. That's land used primarily for residential, commercial, or industrial purposes lying outside the corporate limits of any city, town, or village. So actually, if you study the definitions of these conditions, suburban isn't quite what you think. It's outside city limits. It's really going to be more county land. And urban, most of the time, is going to be your classic suburb, Colleyville, Plano, Southlake, that kind of stuff. Or even city of Dallas if it's not downtown. And the last condition is called Condition 4, rural. This is fairly rare. It's land outside urban and suburban conditions which is unused or used solely for the production of crops, livestock, or minerals. A classic, true ranch-only type land. The thing to remember is that nearly all surveys used for residential title insurance purposes are your Category 1A land title survey, Condition 1, 2, or 3. And I'm going to tell you it's usually Condition 1 or Condition 2. Now you know the terms. In addition to these standards from the manual, the trade group, the American Land Title Association, ALTA, partnered with this other trade group called the American Congress on Surveying and Mapping. That's the ACSM. And they promulgated minimum standard detail requirements and classifications for ALTA ACSM land title surveys, these minimum standards. ALTA land title surveys are likewise classified in those 4 they've got a little more categories, but they've got urban, suburban, rural, mountain, or marshland. What you need to know about an ALTA survey is that these standards that they must follow contain a very specific certification requirement on the survey and very specific tolerances for accuracy of measurement. We sometimes call these the Cadillac of surveys. They are used almost exclusively in commercial. I suppose you could commission an ALTA survey for a residential lot, but the standards are so high that it's prohibitively expensive. They carry high liability, and thus they entail a great cost. And I think we've got an example. So if you want to see what an ALTA survey looks like, we're going to jump to our first PDF and take a look. And let's see if I can do this well. So you have this PDF. It says ALTA ACSM Land Title Survey. I'm going to blow it up a little bit here and zoom around so you can see it. Hopefully in all of our examples. Now, this is just the notes here. We haven't even gotten to the survey. But you'll see these notes about different things. He's got 24 notes in here. Areas of concern, he points out, it's signed and sealed. That's the classic mark of any survey, is it bears the seal of a surveyor and is dated. But this is just the first page. Here's an ALTA survey, and I'll back out a little bit here. But you can see it's got quite a bit of detail that you might not find in your classic land title survey here, especially with respect to these types of notes about what things affect the property. So there's an example of an ALTA survey. We might have another one that pops up, but that's just typical here. Okay, let's minimize. Okay. So there are other types of surveys or survey terms that I want you guys to be familiar with. A form board survey, what is that? That is a survey that's used when a builder intends to pour a slab. It is a drawing of where the form boards used to hold the concrete are located, or where they will be located on the lot. It is not, however, a land title survey and cannot be used for insuring purposes. It looks like a survey. It's often drawn by a surveyor. It may even have a seal of a surveyor, but it is not a true title survey. It's certainly not a Category 1A. It is not premised on a title commitment. It does not depict improvements that may exist currently. It does not show easements and setbacks. It may or may not accurately depict boundary lines. Let's take a look at our form board survey just so you see what it looks like. So this, it says Dunhill Homes on there. It looks like a survey. Sure looks like a survey to me. It's done by a surveyor. There's his seal. There's his signature. But if you were to read this certification and look closely at the survey, it doesn't talk about any commitment. It doesn't talk about any particular GF number. Forms only, you will see. So, it's a snapshot of something, but it doesn't show setbacks on this drawing. It doesn't show easements. There may be many other things that affect this real estate. This is really concerned about the house and what it's going to look like. That may have concrete in there, that may not. We'll find out. A topo. We talked a little bit about that. Short for topographical survey. This type of survey shows the elevations of land on the property. In residential, it's useful for determining whether these improvements, whether a house, for example, lies in or out of a floodplain area. In such manner, it may show, for example, finished floor of the improvements, which is what most cities go by. What is the finished floor of this house? Is it 500 feet? Is it 584? Cities look to see that the finished floor of a particular structure is higher than the floodplain, or a certain tolerance higher than the floodplain. In commercial, it's used to help the developer or their engineer determine where improvements may or may not be constructed. Provided these elevations are laid on top of or are supplemental to a title survey, they can be used. It's just extra data. Think of it that way. But the topo data is of little interest to a title company. They don't need this. This is more for developers. And there's those classic lines. I'll kind of zoom in on these. This is a classic topo, or it has topographical data. There are different standards for it, but you see these numbers. So, for example, this area here, I'll blow this up so we can see it a little better. This line represents 694 feet above sea level, 693. You see we're increasing in elevation as we go to this direction, and we're decreasing in elevation. And that may be, in fact, a flood area. So a topo is extremely helpful in commercial for developers and engineers to know where they can and can't locate improvements, what they may need to do, what cities are going to require in terms of flood control. People don't realize this, but when you build a mall or a shopping center or an office building or anything, and you lay a bunch of concrete and you give people places to park, you, by consequence, take up the grass to soak up the water. So many cities require flood control devices, what we call detention areas where water just gathers. Next time you drive by a shopping mall, look for a huge recessed area that looks kind of junky and has lots of trees. That's a detention pond. That's where the water is going to gather from those big parking lots as required by the city. And I kind of jumped ahead, but engineered versus non-engineered survey. What am I talking about here? All surveys done today are engineered in the sense that they use precise metes and bounds to measure and call off courses and distances. But not all survey plats were that way. If you look at DFW residential subdivisions of record prior to, say, 1940, you'll see what a non-engineered survey looks like. And I'm using the term loosely. This is a survey in the sense that it is a subdivision plat. Let's rotate it. It's upside down. Keep going. But this is a subdivision called Preston Ridge, City of Plano. And it has all kinds of data on there, and you see lines. You've got a curved data chart right there. This is how lots are conveyed out of there, and this was done by a surveyor back in 1980 or so. Classic engineered survey. By comparison, look at this plat from 1903. Okay, that's a non-engineered subdivision. You see where we get into trouble. It looks like the surveyor or the landowner just took a ruler and laid out a subdivision and said, okay, these are all 50 feet, 50 feet, 50 feet. Let's blow it up even more. We got a street up here that's about that. And so this type of survey, and a lot of times these lots get traded and sold for decades, and this subdivision never gets redone or re-engineered because there's no need to. And you might, in fact, own Lot 5 and 20 feet of Lot 6, and you carve it up that way, and your survey may use metes and bounds, but you can have problems that are created by non-engineered surveys because they didn't use GPS. They didn't have little pins in the corner right here that would broadcast and be picked up by a satellite and are locatable. And so what happens is surveyors come along and they measure it and they find that there's sometimes more land actually out there than what's shown in the lot. Or there's less land than what's out there. Or there are other types of conflicts. So non-engineered surveys can be problematic, can lead to problems. Mostly lots that have been traded numerous times have resolved all of that, but you will sometimes see problems. And then the terms. You know, I gave you examples of an engineered survey by showing you plats. What is a subdivision plat? What is a title survey? A subdivision plat is a type of survey. It is a graphical representation of real estate, but it is not designed to graphically depict a single tract of land for the benefit of a purchaser or lender. Instead, a subdivision plat is required by law. There are laws out there that whenever a landowner wishes to legally, quote, subdivide a tract into 2 or more lots, they must create a plat and file it of record with the county. Urban or suburban subdivision plats will often have dozens or even hundreds of lots, sometimes grouped into blocks, and often showing streets and alleys and other rights of way. A subdivision plat is rarely usable for title insurance purposes, but we get that question. Well, I don't have a survey, but here's the plat of the subdivision done in '96. Will you accept that? Okay, new versus existing surveys. In both residential and commercial resale transactions, the use of the seller's existing survey has become a common practice. You don't need me to tell you that. When one considers what a survey is, here's my definition. A survey is a representation to the buyer of the boundaries of the land, the location of all improvements, easements, setbacks, and whether any conflicts exist between those improvements and the boundaries, those improvements and the easements, those improvements and the setbacks, in addition to other important matters. If you consider that's what a survey is, and then you consider the value of what you're buying. What are you buying here? Are you buying a single-family residence for $250,000? You buying a home for $500,000 or over $1 million? Are you buying a shopping center? Are you buying an office building? Heck, are you buying a piece of dirt for $50,000? To me, $50,000 is a lot of money. Then, in my opinion, and my opinion only, the use of an existing survey plus affidavit, as required by most title companies and most contracts, is not unlike relying on the seller's existing inspection reports and data for your due diligence and not paying for your own inspections in order to save money. Let's consider some things. A new survey is an actionable representation. You know, a survey is really a representation to you, the purchaser of that survey, of the boundaries of the property, the improvements, everything's shown in it. And quite simply, the law is such that if you didn't buy for it, you can't sue the surveyor for any errors. And yes, surveys do have errors. So in a sense, I'm telling you that you may not rely on a used survey legally. I mean, you might truly rely on it and trust it, but if that thing is wrong, you and your lawyer cannot go to the surveyor and say, you were erroneous, I want to sue you for these errors. He'll say, you didn't buy it, you're not my customer, I made no such certification to you, and he or she is exactly right. There is no legal recourse against an erroneous survey that is used. Another thing to consider is that to properly evaluate the purchase of real estate, it requires due diligence. Due diligence takes money. Skimping on due diligence means skimping on important data needed to assess the purchase. Would you skip the title search or the title policy to save a few bucks? And my little parenthesis says, don't answer this. Know what you think. Would you skip the inspections? Would you take the seller's old inspections? You know, no one wants to pay any money for real estate they aren't going to buy or might not buy, but the more you can convince your buyers that they have to spend some money to kick the tires, the safer you are and the safer they are. So if they drop $1,000 or $1,500 on a survey and inspections and other things, and ultimately they terminate and decide not to do the deal, it was the best money they ever spent. It really was. Additional coverages from the title company, such as the classic survey coverage, ensuring your boundaries, are often not available if an older existing survey is used. It's kind of a depends sort of thing. So I may give it, I may not. I'm often called to make that decision. But how would you like to use an existing survey and there's something wrong, and it's erroneous in some respect, or you have a boundary problem after closing and you find out I got no legal recourse against the surveyor and I didn't get that extra title coverage from the title company, so I've got no recourse against the title company. In fact, that's point number 5. We'll get into that. The survey affidavit itself is simply a sworn statement to the best of the seller's knowledge. So if the affidavit is erroneous or wrong or missing some information, it is the opinion of many lawyers that there's no real legal recourse against a seller. You don't have to prove they intentionally lied, and most sellers are signing those as a matter of course and habit. There's going to be no realistic liability against a seller for anything in the affidavit which omits anything. They are not. In fact, there's even some law and some statutes that say they are not really certifying the survey. They're just saying nothing's changed since the last date. So the last question to you, who will the buyer look to when he or she is told that there is no recourse against the surveyor, no recourse against the seller, or recourse against the title policy of the title company? They're going to say, now, whose idea was it to save me a couple $100 and use an existing survey? You can see I'm making a point here, which is surveys are good. Yes, surveys cost money, and I'm not a surveyor, and I don't have anybody in my family who's a surveyor. This is just my opinion as an attorney. I think they're a very important part of due diligence, just like inspections and sometimes in commercial environmental reports and other things there. So maybe consider using new surveys on your transactions. Maybe consider your buyers purchasing them. Some of the more common issues seen on surveys. I'm kind of getting into the meat of the talk right here. The most, and they're in no particular order, but I've outlined 4 of them. Fences that are located over or behind boundaries lines, as I've poorly typed it there. So we see that all the time. Here's some solutions. The most obvious solution is to move the fence or get rid of it entirely. Now that may be a practical solution. I don't see that done too often, but if you had a commercial deal, for example, and we're talking millions of dollars and the fence is a barbed wire fence, I don't think it would mean that much trouble or that much expense if the fence is not keeping out cattle, if it's just a remnant of a prior owner, for the seller to move it or remove it completely. But often people don't want to do that. It's a pain. So what else can we do? A common solution is a boundary line agreement, or I think it more properly is called an encroachment agreement. I've drafted hundreds of these. It is an agreement between 2 landowners concerning the fence. And the landowners agree in this, and there are many variations. Many title companies and their attorneys have different versions of it, but they all say basically the same thing. We agree that the fence is not the boundary line, even though it sits over here. The boundary line shown in the survey or the boundary line shown in the recorded subdivision plat. An invisible line is our boundary line. And I'm not taking any of your property by virtue of where the fence sits, and you're not taking any of my property by virtue of where the fence sits. We agree on the boundary line. And a good encroachment agreement will also address another issue, which is and I will take care of the fence. It often recites who the fence belongs to. Maybe it belongs to one side more than the other. Maybe they don't know. Maybe the agreement helps them figure that out. But maintenance is a very key issue when you're approaching this. And so it leaves room for discussion. Sometimes the solution is to do nothing and turn to the title company and say, okay, can you just remove, we've got a fence that is located 1 foot inside our boundary line. It's our fence and we placed it behind the boundary line on purpose. Why, title company, are you taking exception to it? Well, I don't know. If you talk to them or you move up the chain to their underwriters, there's this fear that the space in between the fence and the boundary line will be claimed by the other neighbor. And that's what the title companies worry about, is claims. Well, let's just do a little logic here. What is the neighbor doing to claim your property when you set your own fence a foot behind your boundary? Is it their heir is claiming it? What are they? If you can prove that the neighbor is not actually doing anything, and if you can establish or prove or make the title company believe that it's your fence, you put it there or a predecessor put it there, you've maintained it, and it's behind your own boundary and your neighbor's not doing anything, they might take the exception for this matter completely off their title work, and I would ask for survey coverage. I wish I could, right there. Get your boundaries insured, and you deal with it that way, and you say, it's my fence, it's not a problem. So sometimes fences located behind boundary lines are not a problem at all. Common issue number 2, improvements, think buildings, encroach over a building line or a setback line. Okay. First of all, what is a building or setback line? That's a line typically on a plat that says you may not build over this line. Cities often require that. When you go and create a subdivision, they don't want houses that are 0 feet from the curb and some that are 35 feet back and some that are 50. They want them all kind of lined up. That is the nature of a subdivision. So they will put a front setback line and they'll put side setback lines on the plat. One solution might be to actually move the encroaching improvements. And again, if it's a house, if it's a room addition, if it's a window, that may not be practical. If it's an arbor or something that maybe the buyer wants torn down anyway, maybe the improvement is so minor that they're not going to keep it, maybe we can tear it down and we can talk about that. A common solution that I hear about and see is a variance from the city, some sort of letter that says, yeah, we don't mind, it's okay that this is over the building line. It's very important to understand that while that gives a buyer some comfort, that may not truly answer the question, because there are 2 types of setback lines. There are setback lines per a recorded plat, which are not city enforced, and then there are setback lines per city code. So the city has its own code that says we won't green tag a house and approve it unless it is 30 feet from the front. But you might be building in a subdivision that has a 35-foot setback line on the plat. And you go, well, which controls which rules? They both control. They just have different enforcement mechanisms. So the city doesn't care as long as you're 30 feet back, but your neighbor may care or your homeowners association may care. And so that 35-foot platted setback is enforceable from the point of view of your neighbors. Essentially, it's a lawsuit. So if you saw a house going up and they were putting it right against the street, 1 foot setback, and you had a 30-foot setback on your plat, and you didn't like it, you didn't like its structure, you might file a lawsuit to stop the construction and say, hey, they have to follow the plat. A variance letter from the city, which they are giving less and less anyway, is not going to help you in that instance. The city might say, well, you're 30 feet back and we're fine, but your plat says you have to be 35 feet back. We don't care. And so be careful on relying too much on a variance letter. Very often the setbacks you guys are dealing with are not city zoning setbacks. They're platted setbacks. So is there a mandatory homeowners association that enforces these? That might be a different letter. You might get a variance letter from the homeowners association. And variance is essentially a permission letter. We don't mind. Don't increase the variance. A lot of it has to do with when did it happen. If this house has sat there 1/10 of a foot over a platted setback and the HOA enforces it and it's been there 15 years, I bet you can talk the president into giving that letter. If you're in the middle of building the house and you're pushing it 5 feet over because you want more square footage, the HOA is less likely to give you that letter. Well, when we consider that many times this problem, improvements encroach over a building line, may be a claim from the neighbors that you're violating the setback, maybe you go to the who could complain theory. You go to your neighbors and you say, look, my house is over, here's my survey, look, it's half a foot over, this doesn't bother you. And maybe you get something in writing from your immediate neighbors to the right, left, and maybe directly across the street. And with that consent, maybe it's something you or your attorney can record, maybe it's peace of mind, there's different ways. Sometimes you don't want to go to the neighbors, and sometimes you do. This is a highly variable suggestion that truly depends on the circumstances sort of thing. Another solution is a thing that you guys may not have heard of. It's a title policy endorsement, being an add-on to your policy. You have to ask for it and you have to pay extra money for it. It's called the T19.1, and it's a coverage that a title company will give you if they approve it. You know, they won't always give it, but if they approve it and they say, fine, if you suffer monetary loss in various categories, we'll write you a check. I did not include a copy of the T19.1 endorsement in your materials. It's rather lengthy, but I want you guys to just be familiar with this and know what it costs. It costs in residential 10% of the base rate, or 10% of what the seller is paying on the title policy, and 5% if you get survey coverage. It does cover. Does it get rid of the encroachment? No. Does it say that you'll never have a problem selling the house? No. In fact, that's one of the things title insurance is not permitted to do, is insure or guarantee marketability. And a lot of times these things, 1 and 2, are marketability issues. Your buyer may not care, but they're worried about, well, when I sell it, is this going to cause me a problem? That will not come ever from title insurance. Title insurance will just say, hey, if you're ever ordered to move your house, we'll pay you. If you're ever sued, we'll pay the attorney's fees. Those are the kinds of coverages you get from the title endorsement there. The third most common thing are improvements, not fences. We talked about fences that encroach over the boundary lines. That's pretty big. A house or a garage that sits over a boundary line. Common solutions, again, move it. You see that all the time. Again, maybe the encroachment is minor and you do a boundary liner agreement or an encroachment agreement with your neighbor. Maybe you do nothing and you ask the title company to remove it. Look, this is a corner of the house. It's virtually nothing and it's squatting over an alley. It's going over the boundary line, but it's not going into private property. It's going into an alleyway, and it's just a tiny thing, and you don't need to be worried about that because the city is not going to bump its garbage trucks against the corner of my house, against the 1/10 of 1 foot, and therefore they're not going to care. And they might assess that risk and say, okay, we'll remove the exception. This is perhaps the most common thing. When you've got a significant encroachment of your house or improvements over in someone else's land, you end up talking to the neighbor, or your seller does, about buying the land. You purchase a strip of land and you make a new boundary line, essentially. Now, the replat process is very important because that deed to that strip of land, while it's recorded and while you own it, is not platted into your lot. And cities will want you and require you to replat it. So when you're negotiating these concepts, you need to think about replat costs and replat time. Improvements encroach into easement areas. Okay, we see this all the time, pools and houses that go into utility easements. You could obviously remove the improvements. You could get a variance letter from the city. Again, I'm seeing that less and less, but that may be some solution, although easements are generally, when we talk about easements, we're talking about utilities. Some utilities are from the city, classically water and sewer, but the city can't grant a variance, for example, for an easement to Encore. They don't have the right to do that. So you got to go to Encore to see if they're okay with it. And that's really what this analysis and your risk analysis on this breaks down is. Is there anything in the easement? What is it? And how likely is it that I'm going to have to rip up what's sticking into the easement area? Maybe you talk to Encore, or you talk to the city of Dallas, or you talk to them, and you determine that the particular easement is wide enough and you're not in it enough that it's not going to be a problem, or it's very unlikely that you're going to have it be ripped up or have to reconstruct it. Sometimes you don't know whether there are utilities in the easement. There's this service called 1-800-DIG-TESS. I think that's a play on words for dig test. I've never really known the origin of that, but you can call this company and they come out and do a marking, and they spray paint where the lines are, and it may surprise you. There may be nothing there, or there may in fact be lines. They check that out. You might decide, this is an alley easement or this is a utility easement, and they put it in the plat 30 years ago, and it turns out they brought in the utilities from the street, and they're coming in the front, and there's nothing in there. I've confirmed with dig tests, I've confirmed with the city, there is nothing in this easement area. I would just like it abandoned. Well, there is a process by which you can do that. It's lengthy. It sometimes costs money. The city does not give away their easements to you for free. But if you are determined and you want to go through the process, there is a legal process. You may have to have a lawyer help you with it. And then, again, there's this title coverage. Maybe you're not worried about removing anything. Just give me something from the title company that will pay me if I have to move my structure or if I have to fight a claim or those kinds of things. It's a monetary reimbursement thing. Now, Annette, do you want to go into these examples? We still got time? All right. So I've got some examples of some of these problems that we'll just kind of look at and talk about here. So I've got to rotate this guy. So here is a residential survey of a 2-story brick residence, and what was the feature I wanted to talk about here? So what do we have? We have an arbor, let's blow it up even more, sticking a little bit into a 5-foot utility easement in, what's cab N, slide 894? That's cabinet N, slide 94, plat records of Denton County, Texas. Now, I'll tell you, when I'm looking at this survey, the thing that I feel a big woo sigh of relief is this pool and all the concrete is not in it. They did a good job with that. So the only thing that's really sticking into this utility easement is a corner of an arbor. The survey doesn't show what the arbor looks like. I don't know if that's a very solid structure. Is that just a pole that's sticking there? Are these open or loose? A lot of it can be gleaned and learned by going down and visiting. It might turn out that maybe the only thing sticking into this easement is a supporting wood pole. Maybe there's very little. Maybe you investigate and it turns out that although this easement was created in this plat many years ago, there's nothing in it. Or the only thing in it is a water line or a utility line, and that you conclude it is very unlikely that the utility provider, if they need to maintain or get to this easement area, is going to cause you to rip down this whole arbor. Maybe you can't get comfortable with that. Maybe you can't get that, or you don't have time and you say, let's get a title endorsement. Or maybe you hold the line and you say to the seller, look, my buyer is risk averse. He's an engineer. She's an engineer. They don't like any hair on any of their deals, and they don't want to have to guess or conclude there's not going to be a big problem. I just want you to tear it down, or I want you to modify it, or something like that. Maybe you stand tough, but there is a classic example of a structure, a very small structure, intruding into a utility easement. Okay, let's flip this guy around. This is a very nice, big residential property on Windsor Road in Austin, Texas. And there's all sorts of hair on this one that we might deal with. So what do I see? Let's take a look. First of all, when I go to the north, I see, well, there's a stone wall that's sitting in the neighbor's property. And remember, we talked about surveys showing the ownership. This appears to be owned by some folks named Abel or Abel. This is a bit, they have a big house, they have a big house. These people are wealthy, these people are wealthy. When you get into your higher end properties, you worry more about attorneys. Attorneys and fights and litigation becomes more of a factor with high wealth individuals or large high end residential properties. So my first question is, whose stone wall is this? Does this belong to the Abels, or does this belong to our people, and is it encroaching? And look what else sticks out over the boundary line. You got a little bit of this stone drive. So the title company, if they're smart, takes exception to it. What do you want to do about it? That's when you start talking about, well, can we enter into a boundary line agreement or an encroachment agreement? How hard is it for you to drill that out? How bad do we need it? Whose stone wall is it? I can't give you a fixed answer because they all depend on facts. But at least you can kind of look at these things and know what questions to ask, and you probably will be getting with the title company attorney to help solve these problems. Look at this. This nice stone wall curves around. That could be a big tree that it has to curve around. That is a structure that's identified, but it doesn't sit nicely on the boundary. It kind of goes outside. So I ask, okay, what is it protruding into? Well, look, it's another big house. Philip Chase Bobbitt. I could make a lot of jokes there. But it's someone else's property. Or do they have a problem with the stone wall and its location? Those are the kinds of things that you would look on this survey to observe. And then we see more protrusions. Look at this wall goes all the way out here. Well, when we pull out, we look and we see this is Enfield Road. This, the question might be for the title company, is this right-of-way? Is this part of Enfield, or is this private property? Who are we encroaching into? Generally, title companies care a lot less about encroachments into the right-of-way than they do about neighbors. Neighbors act irrational. People act irrational without making a huge political statement. Governments generally don't care that much about this. They're not likely to sue you to remove this sort of thing if it's not interfering with their basic governmental functions, which is maintenance of Enfield Road there. So that might be a thing that you can convince the title company or its underwriter to remove the exception to there. Shared driveway. We haven't talked a lot about this, but here's a survey of a nice little house, and we see this area is depicted as driveway, and this is probably their garage. And look, that's the neighbor's garage. And I bet that people drive in, and while it's not measured, you will notice the distance from the edge of the house to the boundary line is 11.9 feet. The distance from this edge of the house is 10.8. So how wide are we here? I'm gonna guess that's about 8 feet. You could ask the surveyor to go out and measure that and do a revision, and that might cost $50 or $100, I don't know, but it might be helpful. You might think, that's only 8 feet to drive my car. Is my neighbor a jerk? Is my neighbor going, what if this neighbor, the owner of lot 25, is a wonderful lady, and then they sell it to someone who's a jerk and they put up a big wall along here, and logistically I can't get my big wide AMC Pacer, or think of some other wide car, down an 8-foot driveway. This is the kind of thing that you should look at a survey and wonder, do we need some sort of driveway agreement between the two lots now while I'm dealing with nice lady rather than future jerk, whereby we give each other an easement to drive on each other's driveways as necessary. And I'll maintain this 8-foot portion and they'll maintain that 8-foot portion. And, that might be a nice thing, problem you eliminate for your client. And then we've got one more survey we'll look at real quick, and then we'll go to questions. Rotate clockwise. Blow it up. So this appears to be what you might call a townhome by the lot and the survey. So what do I see and notice that just is... Well, first of all, I see this driveway coming in. These two, they probably go all the way back to the back here. And then I see this concrete coming over, and there's our boundary line right there. So here's a big, nice rock wall and a big space between the boundary line and the rock wall. And so the title company perhaps takes exception to it. They take exception to the area between the rock wall and the true boundary line, because if it truly is walled off, then who's likely to consider this strip his or her property? It's the owner, it's the Salazars over here. The owners of this lot. That may require a boundary line agreement. It probably is, you're going to have to talk to some people. You see this residence. Let's see if we can blow this up. The residence is 0.8 feet behind the boundary line. That's fine. Does it come over? We're going to need to talk to the surveyor. This is very, very hard to read, but there certainly appears to be some of the neighbor's concrete coming over the boundary line. Hopefully the house doesn't do anything. That may not be such a big deal, but it's something to look at closely. Whoops. And then lastly, look at what we've got here. So here's our boundary line. If you were to take it from the pin right here all the way here, well, we got a wood deck that goes 3.1 feet over the boundary line. Does the neighbor have a problem with that? We have a chain link fence. Is that our chain link fence or the neighbor's chain link fence? Are we claiming some of this boundary? Does our neighbor think this, in fact, this chain link fence is the boundary line? These are questions to ask. And then lastly, you'll see this note, overhang over property line. While the residence seems to be real close, you see this dashed line right there. And it appears to be, if I look at this measurement, 0.3 feet hanging over our property line, a slight encroachment. Is that a problem for me? Is my neighbor claiming anything? What does that mean for me? And again, You may not have a problem with it, maybe a future buyer does. It's certainly something to consider asking questions about and maybe dealing with it through affirmative insurance, the T19.1, for example, or a boundary agreement, or maybe something else. But by asking questions, you can determine whether these people are at war over this issue or not. Very often they're not, and you can solve it other ways. We have less common issues seen on surveys. Blanket easements, we can talk about overlaps and vacancies, erroneous surveys, lack of access. My question to you, Annette, is do we want to, we're getting near the end of our hour, would you rather go, because I'm sure we've generated a number of questions, so
Yes,
what I'd like to do is suspend this. I intentionally teased you guys and made this long, because I've never done this particular talk before, so I didn't know how long it needed to be. But if anybody wants to contact me after the class is over, my email is ckramer, Kramer, at hklegal.net, and you can email me about anything else that we don't get to. So let's go to questions here.
Can you see those?
All right, so if the seller pays for the survey, we just missed that here.
Yeah, sorry.
Okay, these questions are moving around, forgive me.
There it goes.
If the seller pays for the survey, will the buyer be covered, is one of the questions. Who pays for the survey is simply a matter of contract, and it doesn't determine coverage. So if you obtain a new survey and pay for it at closing, it really doesn't matter to the surveyor whether that money comes from the seller or whether that money comes from the buyer. That is still a certification or a representation, if you want to use a simpler word, of the boundaries of that property to you, the purchaser, whether the purchaser paid for it or not. It's kind of like title insurance. Either the seller can pay for title insurance or the buyer can pay for title insurance, but it's still an insurance policy. So a new survey is a wonderful, good thing. I say buyer pay because that is classic tradition and custom. Most sellers will not obtain a new survey for a buyer in a residential deal. Most sellers will say, I'll give you what I got and I'll sign an affidavit, but if you really want a new survey, you have to pay for it there. All right. Who generally owns the sidewalk in a residential neighborhood? Talk about right-of-way into street. Well, a survey is a classic example of what you would look at to determine whether you own a sidewalk is essentially an easement. It's generally a right for someone else to cross your property. Sidewalks are generally public. You want to look at your survey and perhaps the subdivision plat and see, is the sidewalk located outside the four boundaries of my property, or is it located inside the four boundaries of the property? And again, properties are specific and they can differ. The classic sidewalk setup is that is maintained by the city or homeowners association, but it is possible that you might buy into a very Tony exclusive subdivision where sidewalks are privately maintained. That's why you got to take a close look at your survey, see where it lies, ask the question, and see what it is on your particular property. They're commonly maintained by a homeowners association or the city, but I won't discount the possibility of private maintenance there. It just depends on what the property says. Talk about right-of-way into street. Well, generally, you want to look at your survey and make sure that your property that you're buying is abutting or sits on a public road, a public right-of-way. And most residential subdivisions have that by legal requirement. But if you were buying a piece of land out in the country, and very often you buy a chunk of it and the seller retains the remainder, you don't want to buy a square in the middle of a ranch and not have a road or access easement to get to a public right-of-way. So surveys are very important tools to help you determine whether you've got access to a public right-of-way or not. If you are in fact buying a square in the middle of a larger square of land and the road is outside the larger square, the seller has access to it, but you will be landlocked, then one of the things you're going to need and want to negotiate in your contract is an access easement. I'm not only going to buy this 4 acres, but I'm going to need to buy a 30-foot wide access easement generally here. You might chart it out to be determined by a survey, and you, the seller, will grant me that access easement. And then you got to think about who's going to maintain it, those kinds of things. So access is very important. All right. how much do these boundary agreements cost? Good question. I charge about $250. Some attorneys and title companies may charge less. Some may charge more. You could use that as a median. It's a dirt cheap price for a fairly complicated agreement, but we do them fairly often, so they become routine. But a lot of times in your high-end deals, the title company or I throw out the boundary line agreement, and it gets bandied about by two attorneys, attorney for seller, attorney for neighbor, and it leaves my hands, and it gets changed, and that's fine. Usually it will result in an agreement of some sort that will solve the problem. All right. Is it the GF number that establishes who the survey was created for in case there's an error and the buyer needs recourse? Charles said the use of existing surveys leaves the buyer hanging if there's a problem because they aren't the surveyor's customer. Let me clarify what I'm saying. If you are a buyer of real estate in a contract and you agree in your contract to use the seller's existing survey, and that existing survey has an error in it, it's erroneous, and there's some defect or problem out there that is not reflected on the survey because of a survey error. And again, that is rare. Most surveys are accurate. But if it is erroneous, you, the buyer, as the new owner of the real estate, most of these problems are discovered after you close, cannot go back to the surveyor and sue them or blame them I guess you can, but you're not going to find you have any legal recourse against a surveyor whose work product you, for lack of a better word, stole. We don't think of it as stealing, but that's the surveyor's point of view. You stole my work product. I didn't do this for you. I did it for the seller. So you're not my owner. I didn't draw this for you. You didn't pay me anything. I have no legal privity, is the fancy word. I have no legal relationship with you. You're a stranger to me. So that's what I'm warning about, is maybe consider buying and paying for a survey so that surveyor, in addition to any liability the title company has under their policy, you can have a second connection to the surveyor. That's kind of the point there. If a property has a storage shed in the backyard which is in a utility easement and is not a permanent structure, although it is quite large, although it sounds very specific, this is a common situation, would a T19.1 be recommended in that scenario? Well, the way you phrase the question suggests it's not permanent. I think you talk to the purchaser and say, what would you like? Would you like for the problem to not be there? Or would you like insurance that pays you in case the problem blows up in your face? That's really what a T19.1 is. A T19.1 does not really solve the problem. It doesn't make the structure go away. It doesn't get rid of the encroachment. In fact, it's you got to read it very carefully. It says, we'll pay you if you're sued about it. We'll pay you if a final court order from a utility provider or a neighbor orders the removal of the structure. Well, those are very rare circumstances there. So it can be some help, and it might provide some peace of mind, but it doesn't truly solve the problem. So I throw it in there as a tool to put in your toolbox there. But title insurance rarely fixes everything, especially in the world of encroachments. What about trees that high over a fence of property being sold that is noted on a survey to note liability?
Is that noted?
Is that noted on a survey to note liability? Well, no. Trees are not generally shown on a classic 1A land title survey. If that's something that you have particular experience with, you may want it shown. That is a depends on the circumstances sort of thing. If you're buying property way out in the burbs and all the trees are little bitty twigs, you may not care about it. If you're buying in Lakewood, for example, and you see there are all sorts of trees and they are sitting over utility lines and they're on your property, you might say, why don't we talk to the surveyor and get the trees mapped and let's see how much that costs. And that might be a very good thing for you to mention and ask for. The surveyor will do whatever you ask, it's just going to cost more money. What about county roads? Same right-of-way as city streets. Generally, a county road is a public right-of-way. You will see this in the country where you will see your survey say CR 871. And you might see a notation under that, public right-of-way or right-of-way. That a county road is a public right-of-way. They may not be maintained as well as you like, but it is the right of the public to draw on it there. All right. Are endorsements only available at closing, or can they be purchased later prior to any claims? You can walk up to a title company and say, I have this title policy, and it's written on First American, Chicago Title, Stewart Title, whatever. If that title company you're going to writes on that company, you could say, I'd like an endorsement. Now here's something that you won't get. You cannot pay $50 or $150 and get coverage on a problem that's already there. That the way title insurance works is that it covers the unknown and the invisible risk. So if you got an active fight or you got a problem and you walk up to a title company, your coverage is diminished or denied when you don't disclose relevant facts of the title company. So I would say you can't really, once the problem's already there, once it's an issue, you can't generally get coverage for it. It's for a problem that is studied by the title company and they decide it's not a big risk and nobody's making a claim at present and therefore we'll cover this. And if a claim later pops up, then they deal with it there. But if you've got an existing fight with a neighbor, if you've got an existing conflict or dispute with a neighbor over a survey issue, you're not going to be able to walk up to a title company and say, I'd like to pay $350 for you to deal with this, and they're suddenly going to pay all the attorney's fees to defend that. That's just not how it works. All right. Does a survey reflect ingress and egress owned by someone other than the owner when mineral rights are involved? Mm-hmm. That's a difficult, detailed question. First of all, there are really two different issues. Okay, ingress and egress is quite simply a legal concept. Do you have the right to go over a particular piece of property? Mineral rights impact ingress and egress. Okay. Surveys, the kind of surveys you're seeing are not going to reflect the impact of mineral rights reservations on ingress and egress. Okay, they're just not going to show it. That's a more detailed question. If you have mineral reservations and you're buying something where you're not abutting a right-of-way and you're worried about your access, you really ought to get an attorney to look at that there.
Okay.
All right, so
I think we're done.
We're done.
Yay!
Thank you.
Good.
Thank you, everybody, for listening. And again, you've got my email. Let me give you my phone number if you'd like to call me with additional questions. My phone number is 214-387-4591.